Court of Appeal for Ontario. I filed an appeal based on lies, misconduct, and errors of the judge of the Superior Court. In the court, when I was talking about the case, one of the judges interrupted me and told that you had only 20 minutes and you talked 10 minutes more. I told her that I have more materials to talk about, and she said, "This is a short procedure and you don't have more time." I never heard of short procedure in the appeal, and especially when the judge of lower court wrote 13 pages of endorsement full of lies and illegal materials. 20 minutes short procedure was ridiculous. Another judge who was classmate of defendant's counsel, who didn't disclose it in the court, interrupted me as well, that we know the law and don't talk about the law. I found that these judges don't have the capacity to read and understand factum. So I squeezed the factum in a few pages and sent to them. They returned it because they claimed that they don't accept anything from one side and didn't listen that it doesn't have anything new. It is only a brief material of factum. Their position in this matter is not acceptable because they share their building, which is Osgood Hall, with Law Society of Upper Canada, with same restaurant and library, and also their judges are active in Law Society and Law Department of universities events, which are in close relation with lawyers. In their short judgment, which shows they didn't read or understand the submissions, they repeated the lie of motion judge that his judgment was after judgment of Justice Myers in June 24, 2014. They intentionally ignored 4 court hearings and judgments which were in my favor during 17 months between June 24, 2014 and November 20, 2015, and they had all of them. They ignored all evidences, affidavits, cross-examination, and materials submitted even by the defendant, and only wrote about 2 subjects, which was duty of care and bad faith. Duty of care was one of the subjects in all of our court hearings, and Court of Appeal wrote, "We make no comment on the motion judge's analysis of whether the APEO owes a duty of care to the appellant." It is interesting that Court of Appeal for Ontario makes no comment on one of the important issues in this trial. This is a shameful sign of corruption because they didn't want to accept that APEO had duty of care, and at the same time due to my strong material submitted, they couldn't deny it. Section 14 Professional Engineers Act, Section 1 and 6, Freedom from Discrimination, which is from the Ontario Human Rights Code, Sections 1, 6, 8, and 10, Bill 124, Fair Access to Regulated Professions Act from 2006, and Section 40, Regulation 941 RRO 1990 clearly shows that APO have duty of care for applicants. For the bad faith, they wrote two paragraphs. In paragraph 8, they wrote, quote, in Finney versus Bureau de Quebec in 2004, the Supreme Court held that bad faith conduct includes not only intentional fault, but also serious carelessness or recklessness amounting to a fundamental breakdown of the orderly exercise of authority or an actual abuse of power. Then, contrary to this, in paragraph 9 they wrote, he or she must allege conduct founded upon fraud or oppression or an improper purpose or motive, such as an intention to mislead or deceive or to deliberately cause harm. Instead of accepting paragraph 8, which was decision of highest court in 2004, they accepted paragraph 9, which was decision of lower court in 2003. The Court of Appeal as well as lower court found the APEO is wrongdoer. So they tried to justify that the mistakes were done in good faith, which is totally wrong. Their assumption is wrong. Their conclusion is also wrong. This is ridiculous and worse judgment. In this judgment, court punished the litigant who claimed his right while they tried to justify action of wrongdoer by barbaric law of immunity and calling the clear sign of bad faith as good faith. You can never see it in any other justice system. This is another reason that judges prefer to ignore law and legislation and use common law concept as a magic box, that they can find any contrary decision and pick the one which is in their own interest. They ignored charter rights violation, lies of motion judge, lies of the defendant, legislation such as freedom from discrimination, the Ontario Human Rights Code, Bill 124, Fair Access to Regulated Professions Act 2006, Regulations 941 RRO 1990, Professional Engineers Act, and also licensing guide and application for license and guides to the required experience for licensing. I also attach some precedent cases contrary to their decision, including their own previous decision from the same magic box, because this magic box has as much as we need contrary decisions which makes this justice system unreliable.